So, good morning, everyone. I hope let's wait for 1 or 2 minutes more and then we can start with the session. Hope all of you are keeping safe. Can I get any comments? Am I audible? Can you see me on the screen? Is there any issue? All right, very good morning, all of you. So, today we'll be starting. So, we have decided to start a series at RostrumLegal, with topic wise with respect to your judiciary preparation so that it may help you slowly and gradually to build upon your concepts. Uh, I'll be choosing very simple and small topics every day, subject wise, so that meanwhile, like although we have our own judiciary badge, but meanwhile, when we are running that judiciary badge, we can also complete most of the concepts for most of you. You are not having any kind of accessibility, so that is the idea. So today I'm starting with Indian Evidence Act. You'll be getting this schedule for this for 1 week in advance. So let's start with it. Why to wait? No, I was just hoping that some more people can join in. So audible and visible too. That's good. All right. All right. Okay. So let's begin. See, whenever we talk about Indian Evidence Act, so Indian Evidence Act is all about, in simple line, if I can say that Indian Evidence Act is all about proving and disproving the fact, right? And that is why you have fact and issue, you have relevant facts and other concepts. Now, I'll make a separate video on fact and issue and relevant facts, so I'm not going into the detail of it. And I have already made a video on, that was a live session on that. What are the cardinal principles of Indian Evidence Act? So the link is provided in the description box. You can just go and have a look at it before, starting with your Evidence Act. Now, the thing is that, as I said, that in Indian Evidence Act, everything revolves around, proving and disproving a fact. So just take a situation where, the other party's burden of proof, of evidence, reduces to an extent in a judicial proceeding or in a suit. And how will it happen? So let's imagine a situation or assume a situation where one party to a suit or proceeding has actually, admitted on some fact. Now that fact can be a fact in issue or that fact can be a relevant fact. So once a party admits, into some fact which is beneficial or in interest of the other party and it reduces the burden of the other party, so that is considered to be a relevant fact. So when we'll be reading further, we get to know that, from section 5 to or 6 to 55, we basically deal with relevant fact. Now I'll not get into the detail of it because the topic of today's discussion is admission. So admission is basically a voluntary acknowledgement of a fact. And this voluntary acknowledgement has to be clear. It has to be an unequivocal statement. It cannot be just any statement. We have to understand this thing. Do let me know in the comment box if you're able to understand what I am saying, everyone. It will be easier for me and then I can proceed ahead. Have you understood till now what I said? All right. So what I say is that admission is a voluntary acknowledgement with respect to a particular fact. All right. Great. Now, as I said, that when a party to a suit or a proceeding admits a particular fact, so it And that admission can be, that voluntary acknowledgement can be, I'm saying the word voluntary acknowledgement, always keep this thing in mind, that it has to be a voluntary acknowledgement. You cannot coerce somebody to admit, right? Yes, you can, uh, ask someone, or you can lead someone to admit something under some disguise. Now we have a separate section in your Indian Evidence Act dealing with it, but you cannot coerce to admit. But that is one thing that has to be very clear. Okay, then what is admission? Has it been defined anywhere? Let's go one by one, in simple terms. So particularly in your Indian Evidence Act from section 17 to 20, when we talk about, these are the sections which deal with your admission, right? Or the concept of admission, or the definition of admission. Although when you read section 17, it says admission defined. So today we'll be trying to answer certain questions. And what are the questions? The questions to be answered is that, we'll try to see that what is an admission, first of all. Then we will also try to understand that are there any kinds of admission? Fine. And then, right? Then what we do? We try to understand that who are those people basically, whose admissions are relevant in Indian Evidence Act. Not everybody's statement is relevant. Not everybody's admissions is relevant. There are bound to be some people whose admission or whose voluntary acknowledgement is relevant as far as Indian Evidence Act is concerned. So these are the three questions which we are going to answer today. Fine. Now, let's deal with them one by one. Yahan tak, everyone, have you understood? Can we move ahead? All right. Fine. So what is basically an admission? Now that is section 17 which talks about it. So section 17 says an admission is first of all, a statement, right? So what is an admission? So an admission is a statement. Very good. What kind of statement? So this statement can be oral, or it can be documentary, or it can be contained in any electronic form. Now that was an amendment which was made. So any statement which is oral, documentary, or contained in electronic form, what this statement does, which suggests any inference as to any fact in issue or relevant fact. All right? And which is made by any of the persons and under the circumstances herein after mentioned. That means that in the provisions, what is mentioned. So I'll read the section once again. An admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. All right, fine. Then what next? So what do we understand by this? So basically, it's trying to answer the first question where we were looking for that what is actually admission. So let's understand what are the elements of admission as far as section 17 is concerned. So it defines admission as a statement which is oral, documentary, or in electronic form, right? So whether it's an oral statement, whether it's a documentary statement, or whether it is in electronic form, that is an admission. All right, very good. Now what else? It suggests an inference. The word "an" is missing over there. So it suggests an inference as to fact and issue or relevant fact. So when I say the word inference, so when the section provides the word inference, all right, this does not mean that, it's just a mere presumption. It means that, it is, because admission, you have to remember, if we go by section 31. So it says that admission is a substantive piece of evidence. So the inference has not to be, concluded on the basis of that it is just nothing but a suggestion. No, it is not just a suggestion. It is a statement which do helps the party to prove a particular fact or to disprove a particular fact, and that is a substantive piece of evidence. But inference in the sense that although it is a substantive piece of evidence, but this is not something which is going to stop. This is, sorry, it can act as a stopper, but this is not something which is going to be a conclusive proof. Now, that is what we have to understand. And that is where the basic difference between admission and confession lies. Because when we talk of confession, it's considered to be a conclusive proof. But when we talk of admission, it is not considered to be a conclusive proof. But yes, it is a substantive piece of evidence. Then it has to be made by persons and under circumstances which is provided in your sections. All right, which is there in your sections. Which are those sections? So these are some important points related to section 17. It says that only admission of facts bind the maker and not admission of law, because when I say that only admission of fact binds the maker, not admission of law, because admission of law, by admission of law, you cannot stop a person, right? It cannot act as a stopper. So the statute cannot be act as a stopper. That is what you have to understand. You cannot bid a law against a law. So that is how. So you cannot defeat the purpose of law by saying that, that this was an admission of law, and that is why the party has been stopped in doing a particular act. And that is one thing. Then, as I already told you, that admission, when you say it is a statement, that statement has to be a clear statement, that statement has to be an unequivocal statement, and it should not be a truncated evidence. Now, what is a truncated evidence? What do we mean by truncated evidence? All right. Truncated evidence simply means where parties' evidence falls the requisites of a totality of the evidence or a legal proof. That means there is some deficiency, some loophole, some problem in that, evidence which cannot be relied upon in order to prove or disprove a particular fact. Is it clear? Yahan tak, everyone? Are you able to understand what I am saying? Can we go further? All right. Right? We'll be coming to the illustration. All right. So the next question which we are trying to answer is, are there any kinds of admission or forms of admission? Yes, there are kinds of admission. So one is your judicial admission and the other is your extrajudicial admission. Now, what is a judicial admission? Judicial admission is a statement which you give before the judicial magistrate, before the trial, and it is binding in nature. It is fully binding in nature. All right. And it do not, even if, like, what happens to the extrajudicial confession, when you talk about the extrajudicial confession, it does not appear on record, and this cannot be a waiver of proof, right? Although it is partially binding in nature, and that is the basic difference between these two concepts. So when you talk of a judicial confession, so a judicial confession is something which actually you can give before the magistrate and it is binding in nature. Extrajudicial confession is something which is not binding in nature, although it is partially binding in nature, but it does not appear on the record and you do not give it before the magistrate. You can give it before any person, any friend, any stranger, or any, if you are a prisoner, if the person is a prisoner, is in the prison, so any inmate, so on and so forth, right? So this is the second thing that we have understood. All right. Can you just give me a please? All right, am I visible to all of you? Am I visible? All right, I'm really sorry for this, for what has happened. I'm really sorry for that small disturbance. Okay, can we get back to the topic? Are you with me? All of you, are you listening? Can I? Okay, thank you so much. Thank you for staying there. Thank you for your patience. Then let's start again. So we were starting with section 18. So just listen to me carefully, and we can just continue this topic and finish it whatever I've decided for you today. So as I said that when we talk about section 17, so section 17, it starts with that admission defines. But in the beginning only I told you that it is not just section 17. So section 17, 18, 19 and 20, they combine together to help us understand that what is actually admission. Because when you read the definition of section 17, it says by persons and under the circumstances hereinafter provided. So I'll just go back to it, you know, and point this out again. Let's see that. What does it says? Let me repeat it. So it says, Section 17 define admission as a statement which is oral or documentary or contained in an electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. So we know that this is an oral statement, number one, and it can be a documentary or electronic statement. First of all, it is a statement. It can be an oral, documentary, or electronic statement. This statement suggests a kind of inference related to what? Related to any fact in issue or a relevant fact. Fine? We have an understanding on that. And it is said by whom and under what circumstances? Can we say that every statement of a person is an admission? No. Can we say that the statement given by any person under all the circumstances is an admission? No. There are certain provisions which are provided itself in your Indian Evidence Act which talks about this thing. Then we also discussed, that are there any kinds of admission? Yes, there are kinds of admission, and what are they? So judicial and extrajudicial. So when we talk of a judicial confession, that means such a confession is made before the magistrate, before the court. This is a confession and that is made before the trial starts. When we'll be doing section 164 of your CRPC, basically it deals with that part of the confession, judicial confession. This is a confession which is on record. So this is a confession which is binding in nature. And that is why it acts as a waiver of proof. So once a confession has been done or once an admission has been done, so this judicial admission acts as a binding proof for the, waiver of proof for the other party. Now, what do we mean by extrajudicial confession? So, extrajudicial confession is something which is definitely not before the court. So, it is made someone outside the court or outside the authority of the magistrate. So, it can be any person. As I said before, it can be your friend, it can be a stranger, it can be a passerby, it can be a jail inmate, it can be anyone in the family, and anybody. And it does not appears to be on record, right? So that is why it is partially binding in nature, except where you have to exercise the principle of estoppel. So we are done with this. Now let's talk about section 18. That what does section 18 says? Fine. So I'll just shift to that. Fine. So section 18 is basically trying to answer the second question, if you remember, which we asked about that, whose admission is relevant, or the admission given by what kind of person, or what kind of, or who are those people whose statement as an admission would be found, I can say admissible, or if not admissible at the very first place, relevant in the proceeding or in a suit. So Section 18 gives the answer for it. Section 18 says admission by party to proceeding or his agent. So I'll just read the entire section and then I'll get back to you. So it says admission by party to proceeding or his agent. Now this is one category. So it states that statements made by a party to the proceeding or by an agent to any such party whom the courts regard under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. So this is one situation where the admission is being made by a party to the proceeding or his agent, right? And that agent cannot be just any agent. That agent has to be a duly authorized agent, whether that authorization has been given expressly, right, through a letter or through a document or through an agreement, or it has been given impliedly. For example, the person is working for you, the person is representing you at different places, and people by his conduct consider him to be your agent. So that is an implied authorization of agency, right? So statement given by such people. So if a suit is going on or if a proceeding is going on, so if the party gives any statement or the agent of the party gives any statement, so that will be considered as an admission. Then what next? By suitor in representative character. So if there is a suit where a representative character is involved, or let's take the example of a public interest litigation, PIL. So it says that statements made by parties to suits suing or sued in a representative character are not admissions unless they were made while the party making them held that character. Now, what does that mean? It simply means just when this suit is being going on and the person who is being sued or the person who is suing has done so is in the representative character, means it is representing a whole bunch of people or a group of people, then in that particular case, whatever statement is being given by the person in that representative character meaning thereby the representative character of being sued or when he is suing, right? So whether in a particular case, whether he is a plaintiff or he is a defendant, in both the cases, and that capacity he is holding in a representative character. So any statement given by the person when he is holding that representative character, that statement as an admission becomes relevant. That statement as an admission becomes important. Is it clear, everyone? Is it clear? All right. Now let's move on to the next. The next point in the section says that, or the next clause says that the statements made by number one, party interested in the subject matter or persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of persons so interested. Now let's take an example of that a party, uh, you know, someone has a charge on a property. So that person has a pecuniary interest in that subject matter, right? On that property, or someone has a proprietary interest in that property or in that disputed fact, whatever is the issue, fact and issue in that particular case, or with respect to the subject matter of the proceeding. So that person will be interested in the result or in the consequence of the matter in dispute that is being decided. Now, if a person is A, now let's take this example that if a person is A and this particular person has a, let me write it here, has a charge, right? this particular person has a charge on the property, which is a dispute, which is in dispute, which is in the court. So whatever income the person is drawing from that property, the person would be interested in that money, in that income. Yes or no? Can I get some yes or no, please? Right? Are you able to understand what I am saying? Fine. So if a statement has been given by, that particular person with respect to the property or with respect to the matter in dispute, so that statement becomes a important statement, and that statement becomes a statement which can be considered as an admission, and that is relevant in this particular as far as your Evidence Act is concerned. Now 2 says that, let's move further. A statement by person from whom interest derived. So person from whom the parties to the suit have derived their interest in the subject matter of the suit are admissions if they are made during the continuance of the interest of the person making the statement. Meaning thereby, if A is the father of B and C, let's take an example that, if A, so A is the father of, right, B and C, and B and C, they have derived their interest with respect to a, let's assume, a property, all right, with respect to a property from the father. They have derived their interest from the father, and the father has made the division in a particular manner that, this much share of the property is going to B and that much share of the property will be going to C. But later on, when a dispute arises with respect to the property, suppose a suit arises with respect to the property, so the statement given by with the and the suit is with respect to the amount of share in the property. So the statement given by A, who is the father, from whom B and C are deriving their, interest. So that statement is considered to be an admission if it is with respect to the matter in dispute, and the statements are made during the continuance of the interest of the person making the statement. All right. So when the person was having the interest, and if the person makes the statement with respect to the disputed matter, so the statement of A becomes relevant over here. Although he is not a party to the dispute, although he is not a party to the suit, but here, this is an example of that how the statement of a stranger also, in that particular case becomes relevant. It becomes a admission. Is it clear, everyone? So let's see the important elements of it. So what are the elements of section 18 which we have discussed right now? That either the statement given by the party to the suit or proceeding, or the statement given by the authorized agent. Now this authorization can be express or it can be implied, or if there is any party who is suing or being sued in a representative character, all right, and the statement has to be made by the party in that representative character, or the person having a pecuniary or proprietary interest in the subject matter of the dispute, all right, or the person, the statement of the person from whom the party have derived their interest. So this is the element of section 18 which you have to keep in mind when you are describing upon it. So all these statements become a admission. Fine. Is it okay, everyone? Have you understood? आगे चले section 19. Fine. Let's talk about section 19. Now section 19 हमेशा से लोगों को थोड़ा सा लगता है it's tricky, but it's not at all, right? You just have to understand the crux of what section 19 is talking about. See, section 19 talks about a situation where the admissions by person whose position must be proved as against party to suit. So again, it is talking about a person. So it is talking about whose admission is relevant particularly. Do not forget that we are dealing with somewhere between section, वैसे तो section 6 से start होता है, but I also take into consideration section 5 as well. So do not forget that we are dealing from section 5 to 55. That is a relevant fact. So whatever we are discussing right now is a part of the relevant fact which we'll be doing later. Now coming back to section 19. Let me erase this. Just give me a moment. All right. Now coming back to section 19, it also talks about someone who can actually, provide the admission. Now who is that? Let's read. So it says that statements made by persons whose possession or liability it is necessary to prove as against, I read again. Statements made by persons whose possession or liability it is necessary to prove as against any party to the suit are admission if such statements would be relevant as against such persons in relation to such possession or liability in a suit brought by or against them, and they are made while the person making them occupies such possession or is subject to such liability. Have you read the provision, everyone? What does it say? It says, I repeat, statements made by persons whose possession or liability it is necessary to prove as against any party to the suit are admissions if such statements would be relevant as against such persons in relation to such possession or liability in a suit brought by or against them, and they are made whilst the person making them occupies such position or is subject to such liability. Can anyone tell me how many people we are talking about here? Can you tell me how many number of people are related over here? I'm waiting for your answer. कितने लोग इन्वॉल्व हैं इस प्रोविजन में? Anybody? See, we are talking about 3 people. In this particular case, we are talking about 3 people. Let's presume we are talking about A, B, C. Okay? We read the illustration and then things get clear, and then I'll explain it to you. I'll write A, B, C here. A, B, C. Now what does the illustration says? It says A undertakes to collect rents for B. Just imagine this situation. What is it saying? It's saying A undertakes to collect rents for B. So that means who is B? B is, let's assume B is the landlord, right? Fine. So A undertakes to collect rents for B. B sues A for not collecting rent due from C. So A undertakes that he will be collecting the rent. All right. He will be collecting the rent. Fine. Which is due to B from C. C is the tenant. Let's take, that C is tenant. Fine. And this C has to provide rent to B. Clear? The C has to provide rent to B. And for that purpose, A has undertaken that, he has given an undertaking that, or he has promised that he will be collecting this rent which is due from C to B, all right, from C. Is it clear, everyone? मैं फिर से समझा रही हूँ. A, B, C तीन लोग हैं. B सपोज करिए लैंडलॉर्ड है, C टेनेंट है, ऑलराइट. एंड A ने ये प्रॉमिस किया है B से कि A जो है वो C जो रेंट ड्यू है, सो दैट रेंट A जो है वो कलेक्ट करेगा C से एंड वो कलेक्ट करके B को देगा. अब क्लियर है everybody? So there are three people involved into it. Fine. So I read the illustration. One undertakes to collect rents for B. B sues A for not collecting rent due from C to B. A denies that rent was due from C to B. Now what has happened? A ने कह तो दिया. A promised that okay fine, I'll be collecting the rent. But A did not do so. A did not collect the rent. All right. Or it might would have happened that he has collected the rent, but he has not paid that over to B. Now that can be both the circumstances, right? In this illustration, they says that B sues A, that the landlord sues A for not collecting rent due from C to B. A denies that rent was due from C to B. Ab this Mr. A, he denies कि भाई कोई rent due ही नहीं था. There was no rent which was due, right, from C to B. So where is the collection? Where the question of collection comes? Where then this suit is, this suit does not stand at all. Now what will happen? Just imagine a situation. If C comes forward, if this tenant, if this tenant comes forward and he says, yes, I am a tenant and the rent was due and I was supposed to pay the rent, or I have paid the rent to A. Don't you think that the statement which is given by C stands as an admission and is a relevant fact against A? What is your answer? I'm waiting for your answer. If you have understood the illustration, let me know, please. Right? So the statement which is given by this, the C, that is a relevant fact against A. And why it is a relevant fact against A? Because your section says that the liability or the position of C would have been important if B would have directly brought a suit against C. Yes or no? Right? You understand? So the liability or the position of C would have been important if B as a landlord would have brought a suit against C. So that is why it becomes important. That is why the statement given by C becomes a relevant fact, and he is giving that statement continuing the position or the liability which he has, that is in the capacity of the tenant. So I'll just go to the last statement which the section says. It says, just focus over here. All right, I read. Statements made by persons whose position or liability, his position in tenancy and liability, that is C, person who they're talking about C, right? So statements made by persons whose position or liability it is necessary to prove as against any party to the suit are admissions if such statements would be relevant as against such person. When it would have been relevant? It would have been relevant in relation to such position or liability. Which position or liability? Position or liability of a tenancy or as a tenant. All right? Or the liability as a tenant. Fine? Such position or liability in a suit brought by or against them. So if C would have brought suit against B, or if B would have brought a suit against C, and at that time, at that time of the suit, if he would have given any statement with respect to his position or liability, so that statement becomes relevant as a admission statement. Okay, everyone? Am I able to make you understand? You need to tell me. I'll repeat, no issues. All right. So let me now read the illustration again. So that is why I say that section 19 is very simple. You just have to keep one thing in mind, that there are three people involved into it, and take this example of landlord and tenant. So let's, read once again. So it says A undertakes to collect rents for B. B sues A for not collecting rent due from C to B. A denies that rent was due from C to B. A statement by C, all right, a statement by C that he owed B rent is an admission and is a relevant fact as against A if A denies that C did owe rent to B. Clear? Now let's go ahead. So what are the important elements? So important element is section 19. One thing that you have to keep in mind, that admission of that person whose position or liability is necessary to prove if the suit was brought by or against him. They are talking about that statement. Now let's quickly come to section 20, which is the last section of today's session. It says that admissions by persons expressly referred to by party to suit. I repeat, admissions by person. All right. Admissions by, who are these persons? By persons expressly referred by party to suit. So just suppose, you just take an example of that a matter is being going on, or a dispute is being going on between A and B. Again, here the statement given by the stranger becomes, important. So that is an exception to the privity rule. If you can see, I hope you know privity rule. I'm saying this on the presumption of that you know privity rule. If not, let me know in the comment box. I'll, make a separate video on that. All right. So admissions by persons expressly referred to by party to suit, what does that mean? It simply means that, let's read the provision first. I'll explain it to you. Statements made by persons to whom a party to a suit has expressly referred for information in reference to a matter in dispute are admissions. I repeat, statements made by persons to whom a party to the suit has expressly referred. Now, a suit is going on. There is a matter in dispute, and one of the party to the suit has expressly referred. Now, what is important is expressly referred. We are not talking about any implied referral, right? We are talking about expressly. The person should be named, the person should be pointed out, the person should be identified, that you just go and ask him. So it says that statement made by persons to whom a party to the suit, suppose there is a dispute between A and B, suit is going on, all right, has expressly referred for information in reference to a matter in dispute or admission. A says that if you don't agree to me, you just go and ask C. He knows about the dispute all, or he knows about the subject matter all. So whatever statement given by C, who is being expressly referred by A, so that statement becomes a admission. All right, that statement becomes a admission. Fine. Is it clear? Right? What does it say? Let's read the illustration, and the things will be clear. Okay, so illustration says the question is whether a horse sold by A to B is sound. Now suppose there is a dispute between A and B, that whether this horse is sound or not. There's a dispute with respect to that, right? Now A says to B, go and ask C. C knows all about it. So who is C? First of all, C is being expressly referred by A. Let go and ask C. Who is C? C is a third person. C is a stranger to the dispute. Again, an exception to the privity, right? So but he says that C knows all about it. So whatever statement is being given by C, whatever statement he gives over here, right? So that statement becomes an admission. And that is a relevant fact. Is it clear? So what are the elements we can, just conclude? We can conclude that First, the person has to be expressly referred by the party. Then it has to be expressly referred by the party. This referral should be with respect to dispute. You cannot, we are not talking about the provision, does not say, or the requirement of the provision is that whatever referral you are doing or whatever information you are trying to, seek, that information has to be with respect to a particular dispute and not just any information. What does any information has to be, what relevancy the information carries with respect to a dispute? Here we are talking only about a dispute. In a dispute, you have to prove a particular fact or disprove a fact, right? So that express reference has to be done with respect to a dispute. किसी भी झगड़ा से related वाद जिसे हम कहते हैं, any suit, any लड़ाई, any subject matter, उससे related when you have expressly referred the person. Why you have referred that person? You have referred the person for the purpose of information. Fine? Related to the dispute and not just any information. Fine. So I am done with this. What I was supposed to complete with you today. I'm really sorry for that hiccup in in the intervening session. So let me know if you have understood what I have said to you. Right? If you have any question, you can just send me a question, or yes, you can also suggest me that, although I'll be completing this admission and confession part, this is just part one. We have a lot to do about admission and confession. As in the beginning, I told you that, admission is a voluntary acknowledgement, but it is a substantive evidence, but it is not a conclusive proof. So we have to do all these sections, right? So section 31 basically talk about it, but admission can act as a stopple. So if you have, said a statement, so what is a stopple? So stopple is like you cannot, after saying a statement, you cannot go back on the statement. So we say that you cannot approbate or reprobate at the same time, or you cannot, blow hot and cold at the same time. Same is the thing with admission, because it is a voluntary acknowledgement. आपने खुद से किया है, voluntary. Your will is involved into it. Your volition is involved into it. So when you have, it is deliberate, it is intentional. So if you have done that admission, so you cannot go back upon it, right? So that is what. Yes, Salus Populus Suprema Lex. Can we say that Salus Populus Suprema Lex, that is the welfare of the people, is is the utmost need? Right? Can we say that it will apply in this particular case, in the case of admission? Anyone? Can anyone answer this? First of all, we need to understand what is Salus Populus, right? Maxim. What is Salus Popula maxim? Please reply in the chat box. What is the Salus Popula maxim? Priya, can you answer that? Public welfare. So is your question that, yes, welfare of people is supreme, right? So if I'm understanding your question correctly, are you saying that, that does admission apply in the case of welfare of people as well? Because welfare of people is supreme. So can we waive off the admission? That is what you're trying to ask? Or something else? Or if you can just elaborate your question a bit. See, try to understand something. So, welfare of the people is definitely paramount, all right? No doubt about it. But when we are talking about proving and disproving of the fact, and that, you know, that admission, if you have to prove, it's actually helping the judicial proceeding into easing out the process of as far as the evidentiary value of a particular fact is concerned. So, why not, right? So, that will always depend upon the facts and circumstances of the case. Once we see the facts and circumstances of the case and weighs the pros and cons, and then only we can reach to this conclusion that whether this maxim absolutely apply in a particular situation or not. Exactly, exactly. But the point is, again, I repeat, that will depend upon the facts and circumstances of each and every case. All right, everyone. So I'm done for today's class. Thank you so much. Tomorrow we are meeting with a new topic and a new subject. This we will be continuing, in the next class of the evidence next week, and I'll try to finish off and cover as much as possible. So hope to see you all there, right? I think that will be at the same time. Hope we don't have any hiccups. Hope we don't have any problem or disturbance. And once again, yes, definitely I'm going to take more classes. Every day. Every day at 9 a.m. we are meeting. All right? Fine. So stay safe, all of you. Thank you. Thank you so much. We'll be meeting again.